Good evening. Can everyone hear me okay?
Yes.
Wonderful. My name is Michael Waterstone, and I have the honor of being the dean at our law school, UCLA School of Law. It's my pleasure to welcome you to the 2023 Melville B. Nimmer Memorial Lecture with Pamela Samuelson. For those of you joining us remotely by electronic feed, hopefully you're good and can see us. Thank you for participating, and for everybody that is here in person, we're thrilled to give you a big welcome and thank you for coming. Before we continue, I want to acknowledge that UCLA Law sits on the traditional, ancestral, and unceded territory of the Gabrielino Tongva peoples. As members of a land-grant institution, we at UCLA pay our respects to the ancestors, elders, and relatives, past, present, and emerging. So as many of you know, I'm relatively new to our community, which is wonderful because everything I get to experience right now is a first, and I'm still getting comfortable with the rhythms of the year. But I don't need to know a lot to know what a special event tonight is. I love moments like this that bring together our entire community. So if I could just ask by a rough show of hands, how many students do we have here? Wonderful. Thank you for coming. Do we have anyone else? Didn't think so. Yes, kind of. Okay. Figured I would check. How many? I know we have a number of faculty colleagues. Thank you for being here. I know we also have some former colleagues who did this actual lecture, which is wonderful. I know we have staff colleagues here as well, friends from the community. So thank you all for coming and being a part of this special evening. One thing that stands out is that the Nimmer Lecture, which brings us all together today, is really a mainstay of our UCLA Law calendar. For more than 3 decades, we've had leading scholars deliver Nimmer Lectures as part of the ongoing celebration of one of UCLA Law's most renowned and respected scholars, Mel Nimmer. His legacy was truly incredible. He was the preeminent copyright scholar of the day, a titan in his field, and a professor at UCLA Law from 1962 until his death in 1985. Mel Nimmer worked with generations of students, and he's widely credited for making UCLA Law one of the preeminent law schools in the world in intellectual property. This is no small thing. The success of our current Ziffrin Institute for Media, Entertainment, Technology, and Sports Law, which is hosting tonight's lecture, thank you very much, and ranks year after year as a leading entertainment law program in the country, rests firmly on the foundation that Mel built. His impact can still be felt today. His success in the 1971 Supreme Court case of Cohen versus California was, and still is, a landmark in free speech and First Amendment law. And his signature academic endeavor, Nimmer on Copyright, remains the field's go-to treatise. Quite simply, when generations of students and lawyers, from those who learned from Mel, down to my classmates when I was in law school, to students today, think copyright, they think Nimmer. So it's my pleasure to thank members of the Nimmer family for continuing this tradition, notably Mel's son, David, has been a long-time lecturer in our community. David, thank you for being here tonight. I also want to extend my thank you to the members of the Nimmer Lecture Committee for their work in making this event possible. So we are honored today with our speaker, Pamela Samuelson. She is the Richard M. Sherman Distinguished Professor of Law at UC Berkeley School of Law. She is a professor of school information and co-director of the Berkeley Center for Law and Technology. So she wears a lot of hats, but the one that fits her best is the one that says eminent authority in intellectual property. Many of her friends and colleagues are joining us tonight, and they know Pam as a trailblazer in the area of digital copyright law. She was there at the start, some 3 decades ago, as one of the leaders in the field. And she's been one of its most published and respected scholars ever since. She sits on the boards of several pioneering organizations, the Electronic Frontier Foundation, the Electronic Privacy Information Center, the Center on Democracy and Technology, and public knowledge, all of which rely on her astounding wisdom. I could go on, and they told me I had 30 minutes, but I'm going to cut it short because I know we really want to hear from her. Pam's lecture today is entitled Fair Use Defenses in Disruptive Technology Cases, and I expect that it will get at many of the key issues that define the practice and study of copyright law today. We are honored that she is here delivering today's Nimmer lecture. Thank you.
So thanks first to the committee for asking me to be this year's Nimmer lecture. In the field of copyright law, there is no lecture that is more prized to have an invitation for than the Nimmer lecture, and so I want to thank David also for his steadfast carrying on of Mel's legacy. Not every son would do such a thing, and so bless you for that. I did actually have the honor to meet Mel Nimmer in the very early 1980s. There was a program at the annual law professor conference that I used to go to because I was the only person teaching intellectual property at my school. I was like lonely, and so to be able to meet people was really like, yeah. Anyway, so I went to this program, and Mel Nimmer, the preeminent person in copyright, Tom McCarthy, the preeminent person in trademarks at the time, and a preeminent person in the patent field were like trying to figure out whether or not the term functionality could have the same meaning, or at least very similar meanings, in copyright, trademark, and patent law. And of course they said, no way. Now me, I've actually thought that there should be some commonality among them, but whatever. So that's what we have. So I had a chance to meet him then, and I actually tried to persuade him to come to University of Pittsburgh for the first conference I ever organized, but it was at a time when he was no longer able to do that, and so I didn't have a second honor, but I'm very pleased to be here today. I will warn you in advance that I have had some differences of opinion with Mel Nimmer, and some of them will be evident today, but I have great respect for him, and so I do want you to kind of know that as we go through my talk. So my talk is titled Various Defenses in Disruptive Technology Cases, and I subtitled it Evolving Conceptions of Harm in Copyright. And I think that's actually an important thing to think about as we now move to trying to understand generative AI and the copyright issues that it poses. It's just the most recent of the disruptive technologies for copyright. And why is it disruptive? Well, it enables new and unexpected uses of in-copyright works. And because it's also been widely adopted by members of the public as well as by a very large number of enterprises, and so is now kind of deeply embedded in our social culture. And when I went to the internet, of course, to ask how many users there are of ChatGPT, the number I got back was 180 million. Now, I don't have verification of that, but it sounds like a pretty large number. And we have actually a dozen lawsuits pending in the US courts challenging generative AI developers with copyright infringement, among other claims. And so what I'm trying to do with this particular lecture is go back to some of the disputes about disruptive technologies in the past and see if there are any lessons that we can extract from those earlier disputes and how they were resolved, so that we can think about how might courts assess the copyright claims against the generative AI developers. I like this quote very much. Copyright today is under stress. It's also under attack. The stress arises primarily because of the rapid succession of marvelous new machines, miraculous enough to delight Jules Verne for copying in new ways and enjoying protected works, and for that reason they're a boon. By the same token, the unauthorized copying of print, sound, and cinematographic works has become an epidemic. Copyright owners can't control as much anymore, and if the source of stress lies in the rapidly changing technologies and in the political force of the attack draws from commercial and non-commercial self-interest, that is to say, researchers who want to make copies of journal articles, and companies like Sony that want to make technologies that allow you people to make copy. The assault weapon is the notion that some proof of harm is a necessary condition for protecting a class of creative industries. Okay, so this is like a theme that you see playing itself out in the generative AI space right now. So what was he talking about at the time? Well, there were lawsuits and controversies about the unlicensed photocopying of journal articles for patrons of libraries. Videotape recording machines allowed consumers to copy programs off broadcast TV, and lots and lots and lots of people were making home tapes of sound recordings that they would be able to listen to when they wanted to. The people who thought that these unlicensed uses were fair uses say, hey, it's not harming any kind of market out there, so it must actually be fair. And Ladd thought that the technologies were causing a large amount of harm and warned that they would have devastating impacts for copyright industries. And so I have this little graphic to show you that in Ladd's conception, there was kind of like a thin band of room for fair use, which was kind of like quotes in book reviews and similar kind of things that were really not going to supplant demand for the original. And so I think that's kind of where things started out in the kind of the early 1980s. Ladd was, of course, at the time the Register of Copyright, so he had a point of view that he was trying to persuade others to enjoy. So the first of the disruptive technology cases that I cover in the paper that I'm preparing for this UCLA Law Review issue had to do with library photocopying. So a company called Williams and Wilkins that published medical research journals. And it found out that the National Institutes of Health and National Library of Medicine, which subscribed to many of these journals, was making copies of these articles for individual researchers, and discovered that 8 copies of articles from his journals were available, were being made available to patrons. And so sued the U.S. government for infringement, and during the course of discovery, discovered that almost 100,000 of these requests were being satisfied, and almost 1 million pages. And what the libraries did is raise a fair use defense to those claims. Now, this was a very close decision, right? Four judges of the Court of Claims upheld the library's fair use claims, saying that the purpose of the copying was for non-profit scientific research. The nature of the copyrighted work was scholarly articles. There had been a 1935 gentleman's agreement between some publishers and some libraries that making copies for scholarly research was actually okay. Now, this was before Xerox machines, right? So Xerox machines made it easier to make high-quality copies, and that made them more upset. The amount copied was small, according to the Court of Claims majority, only 1 article per request. The effect of the market, there wasn't any harm that the court was able to find, or the majority was able to find, because Williams and Wilkins wasn't selling copies of individual articles. It was only selling subscriptions. And nobody was going to stop subscribing, they weren't going to get a lot more subscriptions if there was like only one article out of the issues that they wanted. And the Court of Claims majority also said a finding of infringement here would harm science, and Congress is the better place for the controversies over photocopying to be dealt with, and there was a copyright revision process going on, so that was the place where do that over here, because we don't really have the confidence to set the royalties for all of the photocopying that might be done by libraries. The dissenters, in that case, 3 of them, had a very different perspective on the fair use defense. There is a theory out there that fair use is only available when somebody creates a second work that uses some part of the first work productively, and so then the creation of that new work is basically the thing that makes the justification for fair use, because you're adding to knowledge by making that second work. And so because these copies were not productive uses, they should not be fair. The journal articles, the nature of the work, but you copy the whole of each work, of each article, each of which is separately copyrighted, and the total volume of copying that was happening was really high. And hey, Williams and Wilkins wasn't trying to stop the federal libraries from making copies, they just wanted to get compensated. And the dissenters basically argued the Court of Claims actually has the power to set a royalty rate for photocopies. So when you have then the Williams and Wilkins decision, it looks like the green stuff gets a little thicker here, because the photocopying of scientific articles by libraries for patrons for scientific research purposes seem to be okay. Now, it was the case that the U.S. Supreme Court accepted cert in this particular case and split 4-4, with Justice Blackmun recusing himself because he was the dissenter in the Sony Betamax case that I'm going to talk about really soon. It's almost certain that he would have been the person to be the 5th vote for Williams and Wilkins, but it didn't work out that way because he recused himself. Professor Nimmer, of course, was firmly with Williams and Wilkins and worried that journal publishing would be almost completely supplanted by machine copying over time if we didn't stop now, and so to make sure that there were royalties paid for every copy that was made of journal articles. And I think working with the UCLA Law Review, they published a report about machine copying way back in 1968, and look how many photocopy machines there are out there, and look how many pages of copies are being made for patrons. That report concluded firmly that library photocopying was not fair use, and recommended the formation of a collecting society grant licenses to make photocopies or to impose a tax on photocopy machines with funds going to publishers. Okay? Now, I went into more detail on this particular case than you would ordinarily think, because all of the arguments that are happening in the generative AI space raise exactly the same issues. Okay? So we're just repeating history here, albeit with a different technology. And so you'll see that as we kind of go forward. Now, after the Williams and Wilkins case, Williams and Wilkins kind of said, hey, Congress, why don't you deal with this? And Congress basically said, oh, the publishers and authors, why don't we get together and reach an agreement? And they couldn't do that. And so what they did is they kicked the can to the courts again by saying, well, fair use can basically handle the balancing of interest in that particular case. But Congress also sped off some photocopying issues to the CONTU, the National Commission on New Technological Uses of Copyrighted Works. And CONTU commissioned a study and reported that in 1976, library staff throughout the country had made 53.9 million photocopies of in-copyright materials. And that doesn't count the photocopies that were being made by patrons on the photocopy machines that were available in the libraries. And Cantu said, hey, publishers are earning adequate returns, so there's no need for a big kind of like compulsory license or the like. And nobody wants to reopen the photocopying issue in Congress. But an important thing that Cantu also reported was the formation of the Copyright Clearance Center, which comes to be an important player in some of the subsequent battles. So 2 decades after the Williams and Wilkins case, the Second Circuit, again by a split vote, upheld a class action ruling that Texaco's photocopying of scientific articles from journals was unfair, not fair use, but it was largely because the Copyright Clearance Center had made it easy now to get a license so that the photocopying could be done. So this was a new emerging market that was created. This was the kind of thing that some people in Congress had been hoping for at the time that it was deciding what to do about all of this. And then after that, after the Texaco case, there were a couple of cases against copy shops for making photocopies of articles and chapters of books and the like for course packs. Some of you still may remember the thing about course packs. And Copyright Clearance Center licenses were available for them too. And so the courts in those course pack cases found unfairness also. Although later, more recently, a case involving online course reserve copies was held fair use if the publishers didn't make digital licenses available for online posting. And of course today, we all post things all the time for our courses, and we don't think about copyright really. So anyway, so here's an example of like where fair use circle kind of shrinks, right? If the argument that was being made in Texaco is, oh, this is for scientific purposes, and therefore it's fair use like Williams and Wilkins, the Second Circuit didn't buy it. So the red circle kind of got expanded, and the green circle kind of got contracted a little bit. Second big case, of course, was the Sony Betamax case. 2 motion picture companies sued Sony as a contributory infringer because it knew when it sold these Betamax machines to the public that its customers were making unauthorized copies of movies off broadcast television, and that's terrible. And every copy was, in their view, illegal. Now, a trial court decided that all of the home taping was fair use. The Ninth Circuit, relying very heavily on the Nimmer treatise, decided that actually all of it was unfair, and therefore that Sony was a contributory infringer, but said, well, maybe we won't enjoin it, the sale of these machines in the future. Maybe what we can do is put a tax on the sale of machines instead. But the Supreme Court, as everybody knows, reversed, deciding that time shift copying was actually fair use, and it borrowed from patent law this doctrine called staple item of commerce, so that if a technology has a substantial non-infringing use, even if you know that some of your customers are going to use it for infringement purposes, it's still okay to sell it to customers for their non-infringing purposes. And so, borrowing that concept, because the VTRs had and were capable of substantial non-infringing uses, as in time shifting, Sony should be free to sell the machines to customers for those uses. And the Blackman dissent follows very closely the kind of line of reasoning that you saw in the Williams and Wilkins dissent analysis. Sony, I think, had a lot to say about the harm or market effect factor in copyright law. One thing is because Stevens paid way more attention to the market harm issue than he paid to any of the other factors in that particular case. He noted that there had been a stipulation that Universal and Disney had experienced no harm to date. They had put on experts to say, oh, here's the future harm that's going to happen. People won't go to the movies anymore. They'll sit home and make copies of programs. But the district court had gone to some lengths to analyze the claims of future harm and found them unpersuasive and speculative, and the Supreme Court decided that that factual finding was something that it should defer to. But it also said, you don't actually have to show harm for sure, and you don't even have to show a likelihood of harm in the future, but you have to show something, right? You have to do something to show that there's real meaningful harm out there. One of the things that the Sony decision says that I kind of come back to is a use that has no demonstrable effect on the potential market for or value of the copyrighted work need not be prohibited to protect authors' incentives to create. So he kind of links the presence or absence of harm to whether this is going to have a bad effect on authorial incentives. And he announced the opinion announced a presumption that private non-commercial copying was fair use, and that plaintiffs have to show a meaningful likelihood of harm to overcome this presumption. There is a good question whether that presumption still is valid, but nevertheless it's certainly in the case, and some people do rely on it. Wendy Gordon wrote a very influential article reconceptualizing the Sony case as what she called a market failure rationale for fair use, so that if markets are unlikely to form, for example, to allow people to get permission in advance to make a time shift copies. Oh, let me get in touch with Disney. I want to do this time shift movie right now. Is that okay with you? It's like, who are you going to talk to, and how much are you going to have to pay? It's just a market is really not going to form in that kind of case, and the transaction costs would be high relative to the value to be paid out, so the market was really unlikely to form. And so Sony is now understood by some people as a market failure case. So again, the green circle kind of gets a little wider after the Sony decision. So no longer restricted to quotes and library copying of scientific materials, time shift copies, but also this presumption of private non-commercial use copying being fair. The third disruptive technology I'll focus on for a little bit is obviously audio home taping, and here again Professor Nimmer was out in front with an argument that home taping is not fair use. It's unproductive, the works are creative, whole works are copied, the copies satisfy demand for the original, and the huge volume of taping that was happening at the time. More than 1 billion copies of sound recordings were being made by home tapers in every year in that time period. And the Office of Technology Assessment did a study saying that 4 in 10 Americans had made more than 1 billion copies in one particular year. That's a lot of copies, and so there was a lot of interest in this, and while the Sony case was pending, Congress considered bills to either exempt home taping, which some people thought was going to be the rule, or establish a compulsory license. Why a compulsory license and not a ban is because tape recorders are like in your home, and you can't enforce it. Like, what are you going to do? Break it? Have the police break into everybody's house and seize their tape recorders? That didn't seem to make any sense at all. Anyway, once Sony decided, those bills basically died away. But then Sony had another idea, which was, how about digital audio tape machines? And was ready to essentially flood the American market with these DAT machines, which would enable perfect copies to be made of perfect copies. And that was seen by the recording industry as a really bad thing. So a litigation was ensued where some music publishers and others in the music industry sued Sony to try to stop this, because they thought that actually they had a chance of winning, because the primary use of those technologies was going to be to make copies for librarying purposes, right? It wasn't going to be time shifting anymore, and that issue had been left open in the Sony decision, and so that case ended up being settled by an agreement between the consumer electronics industry and the music industry to support the Audio Home Recording Act, which limited the extent to which DATs could copy music, and also imposed a tax on the DAT machines to go into a fund that would then be available to copyright owners. Computer industry kind of knew what was going on here, and so lobbied for an exclusion of hard drives from the definition of DAT machines in the statute. And once MP3 players, some of you may remember MP3 players, when they came into the market, RIAA sued to stop the sale of those MP3 players, but because they copied from hard drives, they were not DAT machines within the meaning of this definition in the statute. And so what we had is technology bypassing the Audio Home Recording Act. Of course, later, peer-to-peer file sharing came along, and some people said, oh, it's just another form of home copy. But it's like, no, the scale of that is like completely different. And so they were, Napster was found to be an infringer indirectly because it knew that the people were using the system to make infringing copies, and the court found evidence of actual harm and likely harm to emerging markets, and so that's kind of where audio taping. And of course, one of the things about the peer-to-peer file sharing is if I was making a home tape of a sound recording in my home, no one can find that out without breaking down my door. Whereas with peer-to-peer file sharing, you can actually track down the infringers, and that's sort of what happened. There were 30,000 or so lawsuits against individual infringers through peer-to-peer file sharing. Now, Campbell versus Acre Rose is not a disruptive technology case, but as I'll say in a minute, it has implications for them. Everybody knows the facts of Campbell versus Acre Rose. That a unanimous Supreme Court decided that copying of parts of a work for transformative purposes was something that favored fair use, provided a kind of breathing room for the creation of new works, and adopted a definition of transformative from Judge LaValle's article in the Harvard Law Review. The question was, does the defendant's use add something new with a further purpose or different character, altering the first with new expression, meaning, or message? And the court said, yeah, parody does this because it's a kind of critical commentary. But one of the other things that the court said was transformative uses are less likely than non-transformative uses to have negative effects on the market. So nobody's going out to buy Two Live Crew's version of Pretty Woman song if they want to listen to Roy Orbison. Okay, this is just not what you're going to do. And so this was something where the court kind of recognized that harm was more likely in certain kinds of contexts than others. But also the court identified some types of harm that could be caused by the copying actually doesn't count, right? Or doesn't cut against fair use, so that if lethal criticism lowers demand for the original, or copyright owners are unlikely to license this kind of use, copyright owners don't have a sense of humor, so they're not going to license a parody or other critical commentary. And of course, Campbell tells you to weigh the purpose, amount, and market effects together holistically, but it did remand the case for lower court assessment whether there was harm to a licensing market for rap derivatives of songs. And so court recognized that licensed derivatives is something that copyright owners really care about a great deal. Okay, so we have, again, with the Campbell decision, especially the way that it has been interpreted, a growing set of green rings here for transformative uses. Now I'm going to talk just briefly about the computational use cases. So Campbell influenced several cases involving search engines. Because search engines had different purposes in copying, things like images on the internet or text on the internet, than the authors had when they wrote the thing in the first place or when they made the image in the first place. And so that was transformative under Campbell. You copy the whole thing, but it's necessary if you want to be able to index it and create a search engine to serve up contents to users of things that are of interest to them. And you know, when you get the little thumbnail of an image on a search engine, it just tells you that, you know, it's not big enough so that, you know, would supplant demand for buying a copy of it. It allows you to connect to where the image can be found, and that's actually something which doesn't harm copyright markets, might even help them sometimes, and it was a public benefit because the search engines enable people to get more access to information without undermining the copyright owner's interest. The case that many will argue is closest to the generative AI cases is the Author Guild versus Google and Authors Guild versus HathiTrust cases. The court, Second Circuit, and a decision by Judge Laval, decided that Google's copying was transformative because, as in the other search engine cases, it was for a very different purpose than the original. Whole works were copied, but it was necessary to index the contents or enable snippets to be created. And the snippets, according to Judge Laval, did not supplant demand for the original works because they were too short and too fragmentary. Some harm to the market for books might actually happen as a result of Google Books making certain chunks of text available to users, but it's not substantial enough to affect authorial incentives, and the various licensing market proposals that Authors Guild offered were said to be too speculative to count against fair use. So here you have my depiction. You can't read all the small type, but I tried to pick several kinds of things that basically are under Campbell, like making copies of scientific articles to send to the Patent and Trademark Office. You have to reveal what the prior art is in the field where you are, and so patent lawyers basically make copies of it, and then the publisher said, hey, that's a new market for me, and the court basically, a couple of courts basically said no. So I could go into detail on this, but I'm just going to say this has been kind of where we are, and the question that many people in this room will be thinking about is how much this has shrunk or will shrink as a result of the Warhol Foundation versus Goldsmith case, which was decided earlier this year. Okay, now for a really fast run-through of the generative AI cases. So there are 10 class action lawsuits and 2 other against the generative AI developers. The main claims are that these companies have made billions of copies of in-copyright works for purposes of training the AI models, and these copies infringe our reproduction rights. The main defense here is going to be fair use, and outputs of the generative AI systems are infringing derivative works. Again, the main defense that will be put forward, I think, is that outputs are not substantially similar to particular inputs. At least that's the sort of theory that they're relying on, and certainly that's going to be one of the things that people will be fighting about. A secondary defense is that even if determined users can cause some substantially similar output to be generated. Those users are the responsible ones, and my generative AI system has substantial non-infringing uses, and therefore the Sony Safe Harbor applies to me. And you see that actually in some of the comments that were submitted to the Copyright Office in response to their notice of inquiry. Now, I feel like I have to give you at least a 5-minute tour of how generative AI gets developed, because it's wrong to think, oh, here's the model that generates it, must have all the training data in it. It doesn't, okay? It's really a very different kind of process. So the first step is for the developer to identify a domain for the generative AI model. And do I want to generate music? Do I want to generate text? Do I want to generate images? Do I want to generate something else? And then once you kind of know what you want the domain is, you have to then identify and select a data set that will basically that can be used to train the AI model. And after you've kind of picked out your data set, then the humans who are involved in the creation will curate the data set, basically taking out things that you don't want to be there. So some of those things might be duplicates of images that might cause the system to memorize that content, but also hate speech, porn, other kinds of bad content. You don't want the model to be trained on bad data. Once the data set has been curated, the developer then essentially sort of identifies a neural network architecture, an algorithm that is used in the training process, and then the training is an iterative process to essentially convert words to tokens, and tokens then get converted to numbers and assigned to vectors where similar tokens are stored. The transformer architecture was one of the most fundamental of the innovations that led to the current generative AI large language models, because systems before would predict the next word on a word-by-word basis, much slower. So the transformer architecture enables words to be kind of conceptualized in relation to one another so that they could be more accurately identified and essentially put into these parameters that then essentially are the elements that enable the transformer architecture to essentially do what it's supposed to do. So what we're looking for then is a kind of statistical correlation between this word is commonly found next to this word and not found next to that word. And here's how sentences tend to be constructed. The model, once trained, is then able to predict the likely next word in a sequence. And so I thought this one slide would give you a better sense of what's going on. So you can see that the numbers representing, for example, dog, that's a pretty high priority, right? If the words are, I took my pet to, and so what's the missing word? Well, cat or dog is basically high probability. Building and vehicle are very low probability, and so that's how they kind of store the information. Okay. The models are then fine-tuned, sometimes to provide more data, to improve performance and adjust parameters, or sometimes adapt the base model for a more specific type of use case. The model gets deployed, and then you evaluate how well it's doing, and users interact with the model through a user interface such as ChatGPT by entering prompts to identify what the output the users want might be. Couple more things. Training data sets are not the same thing as the model. The model does not contain the training data set in any recognizable form, and once the model has been trained, the data set may no longer be used. So those are two really distinct things. I'm going to fast forward. So the plaintiff's arguments in a nutshell here are generative AI copies our works without our permission, compensation, or credit. It's not justified as transformative fair use because it has a commercial purpose, and the ultimate purpose of using the data to train the model is to enable the generation of outputs that will compete with the original works that we have created, and Warhol Foundation versus Goldsmith is relied upon for those kinds of arguments. And generative AI supplants or suppresses demand for human-authored works because it's so much cheaper and so much faster to use ChatGPT instead of hiring us to do graphic design or write text for us. Some complaints accuse OpenAI and Meta of using pirated books as training data, and that's going to be something which the plaintiffs will make a great deal out of. Of course, you've also heard the kind of in the style of claims also, which seem to be arguing as unfair free riding on our work. So the generative AI companies have a set of defenses that they're raising. They think that actually training data uses are transformative because they have such a different purpose. Also, they involve intermediate copying to extract unprotectable elements, as in the Sega versus Accolade case, which some of you, I expect, know. And as long as the model itself doesn't infringe, there can't be any harm to the copyright owner's market from that intermediate copy that was made. And a big argument is that training data uses are not using the works as works. They're not trying to sort of exploit the expression in the work. They're trying to essentially analyze. They consider the works as data, and they're trying to essentially extract unprotectable elements and create these statistical correlations between these words in context with other words. The argument is it's a non-expressive use of the in-copyright works. Most of the data on which the models were trained was posted voluntarily by people on the internet, and everybody knows that web crawling software goes across the internet making copies all the time. Essentially, one of the cases actually talks about doing that as implied consent. So we'll see whether that has some resonance in these cases. And they argue also that the generative AI outputs are rarely substantially similar, and so in that way they don't pose a harm to either the core or to derivative markets. And hey, look at all the public benefits here. Everybody uses it, and therefore we should allow it to go along. Now, are there some lessons from the disruptive technology cases? I think there are. So I think whether training data ingestion claims are going to succeed will depend on how the courts assess that market factors affect. Speculation about harms is unlikely to suffice, and Sony and the Google Books cases suggest that. The large number of copies made does not by itself show that there has been market harm. And you look for evidence of actual harm or meaningful likelihood of future harm. I think Getty Images has the best chance right now to succeed because it claims that it has an existing market for licensing training data uses of the 12 million images that are on the Getty website. And market failure may also be another consideration, especially in the class action cases, because there isn't in existence a class of authors or artists who could grant a license, and so the formation of a market is a little bit difficult to imagine there. And of course there's a well-known circularity problem in copyright. You know, if you said every time a copyright owner brings a lawsuit, they're saying, well, you should have paid me for that. Well, then it means that you lose every case and fair use would basically go away. And so courts try to push back on the circularity problem. And there are cases that say just because the plaintiff is willing to license doesn't mean that they must license. And other cases that say just because some license this kind of use doesn't mean everybody must do it. And so, concluding thoughts, based on the precedents that I've been reviewing, the generative AI developers have a plausible set of fair use defenses, but of course, every case is decided on its facts. There are some sympathetic plaintiffs out there, and the idea that I won't be able to make a living anymore from my work is actually something that the courts, I think, will be sympathetic to. The pirated books issue is probably going to be a big issue in the cases, even though those books are a very small proportion of the training data. We're also in a time of big tech backlash, and that wasn't true when some of the other cases were decided back then. Google seemed like a good guy, and now everybody hates him. And then the Goldsmith case could end up leading to a cutback in fair use defenses. But here's the thing. If the generative AI developers are infringers, what does that mean for the hundreds of millions of people who are using generative AI on a daily basis? Are they infringers too? And should we destroy the models? Or if there's infringement, again, these cases are in very, very early stages, and it's very hard to predict. But 2 judges already have rejected the claims that all of the outputs of these systems are infringing derivatives, said only infringing if there's evidence of substantial similarity in expression between this input and that output. Again, there may be some cases where that will happen. Well, that will be shown, but maybe not. The last thing that I'll share with you is we're returning to the idea of collective licensing again, right? Do we essentially create a new compulsory license or a collective license regime? And should that focus on issuing licenses for uses of works as training data? Or should it focus on the services that these generative AI companies are offering to the public? One thing that's actually interesting is that if you do the training data license, you might get one shot, right? One compensation, probably not very big, by the way. But whereas with a tax on the service, you end up basically making AI-generated stuff more expensive, and they have to pay on an ongoing basis, and that might generate more compensation, although again, how much actually is owed to each individual author is very difficult to anticipate. The submissions to the Copyright Office in response to their notice of inquiry basically say, oh, voluntary license, voluntary license, voluntary license. But it may be that if what you want to do is create a voluntary license that allows the copying of everything that's on the internet or everything that can be digitized as training data, I don't see how a court can do that. And so Congress may have to get into it, as it did with the Audio Home Recording Act, the Broadcast Cable Compulsory License, and Music Modernization Act. I'm a bit on the skeptical side, but we'll see. So I managed to come in within, I think, 2 minutes of when I was supposed to come in, so thank you. Sorry.
Do we have any questions from the audience? You can just speak up. We have mics in the room so the live stream audience can hear.
Mel Nimmer would have hated this, by the way. Yeah, Jeremy.
Yeah, it's great to see you. In thinking through LLMs, there's a lot of interesting metaphors and conversations about how we know whether large language models are sentient, are agents, are thinking. And I'm just wondering, in some of the conversations, and maybe even in the legal briefing and/or framing, have people ever made just the argument like, why aren't professors essentially just copyright violation machines in exactly the same way that large language models are? Because if you prompt us, we could actually probably cite chapter and verse to lots of things that we've read. Some of the people here have really good memories. But generally we compress and we reconfigure, and most of us probably infringe in exactly the same ways. And so I'm wondering if people have played out that metaphor.
Well, that's actually one of the things that is a point of contention. Can you say that these large language models learn? A lot of the people who are critics say, they don't learn, they're just statistical, right? They're stochastic parrots, and learning is not anything what they do. I'm going to take the perspective of a lot of the companies that are involved in this with a bit of grain of salt. But computer scientists that I know actually think that learning is not an inapt metaphor, and that the emergent qualities that, that these systems manifest, which is they sometimes generate stuff that's like, you couldn't have made this up, right? It's like, it doesn't come from any particular thing. It's this kind of like, here I'm pulling from this kind of thing, from this kind of thing, and then assembling something in response to whatever it is that the prompts ask for the model to generate. And that's something that at least the people that I know who are researchers in this field, they find that actually to be a really significant thing. And also very significant that this extraordinarily complex, I mean, we're talking about trillions of tokens and parameters in these large language models. They cannot be stored on your ordinary PC. They have to be stored in the cloud because they're just too big. And so, you know, they actually think that this is something that is beneficial for society, and partly it's because it democratizes access to a very sophisticated software system that can allow you to do all kinds of things that you couldn't do on your own, and that it's a tool, right? If you think about it, so Microsoft has a metaphor that it likes, and I think it's a very powerful metaphor, which is co-pilot, right? The generative AI is not going to supplant the programmers, is not going to supplant the people who are using these systems, but rather the systems are co-pilots. They're tools that enable you to do some things that you want to do, and of course you're still in charge. Now, whether that story is going to fly with the courts, again, remains to be seen. But there, you know, I've given quite a few talks actually to people in generative AI development and scientific people, and they find it astonishing that anybody could think that this is copyright infringement. Okay, so I have to basically say, I know that you don't think this is really the right idea, but you need to take these cases seriously because courts actually have the power to destroy the models if they find that there's the kind of infringement. And at least the Getty Images complaint asks specifically for a destruction of stable diffusion as a model. Yeah.
So I know that everyone is focused on whether we're going to get some big, splashy fair use ruling, either in favor of or against OpenAI and the generative AI companies. I'm interested in knowing your thoughts on what the likelihood is, or what you think the likelihood is of these cases going the less splashy route, which is settlement. And in that case, as a practical matter, do you think that settlement, I mean, I think when we talk about sympathetic plaintiffs and we talk about getting them compensation, in some ways I think settlement can be touted as this compensation mechanism for all the plaintiffs in the class, but in some ways I'm wondering if settlement is the route that the defendants in these cases would prefer to go, because obviously in a settlement example they would never agree to pay an amount that they can't afford to pay, and they can say they're paying something to rights holders, and there's obviously just one representative for the class that is speaking on behalf of all the rights holders to say the amount is reasonable and fair, but maybe you could say a little bit about how, payments in these classes work and whether any amount that actually gets paid out to the rights holders would adequately compensate them if the harm is as great as they're alleging in their complaints.
So I think the case that is most likely to settle, and that if I was representing somebody, I would be inclined, is the Getty Images case, right? And partly that's because not only does Getty at least say, here's my license to use of our images as training data, and you didn't take a license, therefore you're harming a market that actually exists. And that's something which I think, but in addition to that fair use argument, the Getty complaint actually has good examples of mangled Getty Images logos, and so there's a kind of trademark and violation of the copyright management alteration rules, and so with those three powerful tools, Getty actually is in a pretty good position to get a settlement, and that's the case that I would expect to settle suits. The class action cases, we've had a conversation about this. She loves class actions, and I don't, okay? I'm like really big, not this. So I won't go through all of our arguments, but it seems to me that the class action lawsuits are, most of the class action lawsuits said, I want to represent all of the authors of all of the works that were used as training data. And so how do you get adequate compensation to billions of people for billions of works? I just don't know how you do it, especially given that the internet is a global thing. And so if every country basically says, oh, well, you have to pay me here and you have to pay me here, it's like generative AI kind of doesn't turn out to be a kind of thing that we're going to be able to do. Okay, so, some people would say, yeah, exactly, destroy those things, but that's going to have some ramifications for other people. And you know who's going to make out as a bandit if these class actions settle? The lawyers. Okay, now I have a story, okay, because I was like, I was really closely involved in the attempted settlement of the Google Books case. I think it was maybe the early part of 2008, Google and the Association of American Publishers and the Authors Guild announced, we have this great settlement, and Google will be able to commercialize all of the out-of-print books in the world, and they will be able to keep 37% of the revenues collected from subscriptions that people could get from Google for this, and throw 63% of the money over the wall to a newly created book rights registry that then authors could sign up for, blah, blah, blah. Okay? The settlement amount was $145 million. Now, to get a license to make copies of every book in copyright in the world for $145 million seems like a pretty easy price to me, okay? But how much money was each of the authors going to get? $60, okay? And, the fund would run out, actually, because $40 million of the Google settlement was going to go to creation of the book rights registry and sending out notices to the class members. $45 million was going to go to the lawyers, $30 million to one lawyer and $15 million to another lawyer. That seems to me to be just really corrupt, okay? So if you ask me why am I skeptical about class action lawsuits, it's because the lawyers are in it for the money and the clients get practically nothing. And that's going to be particularly true if we're talking about billions of authors and billions of works, okay? So don't get me started. I think maybe one more, and David, I don't want to keep you from drinks.
Thank you so much, Pam, for such a wonderful talk. You ended by saying Mel Nimmer would have hated this, but I think he would not have hated it. First of all, he would have greatly appreciated that you were mentioning him so many times. And beyond that, I think you were scrupulously honest about his point of view. But it's not the entire story. You're right that the Ninth Circuit in the Sonny Betamax case relied on the treatise, but the Supreme Court majority also relied greatly on the treatise. And when my father was asked about that case, he was not involved in it, he always said it's on the razor's edge, so he did not take a stance that it's fair use or not. But let's just have fun with the last point. Should Congress legislate? The AHRA was a complete failure. Everyone got together in Athens, Greece, and the computer manufacturer, excuse me, the machine manufacturers were there, and the music industry was there, and they worked out everything, and they missed the whole field because Napster came along within the same decade. Broadcast cable has worked for decades. Music Modernization Act is too new. We don't know if it's going to work or not. So here's my question: is it too early to legislate about AI, or is it too late?
Yeah, no, I think those are great questions, and Congress, I think one of the things that's hard about doing some sort of legislative license right now is that things are moving really fast, right? And one of the reasons why I think the Audio Home Recording Act was premature was because it was a backroom deal. It wasn't really kind of like, let's do a serious economic analysis and let's see whether we can actually come up with a good plan. Again, technology bypassed it so rapidly. And generative AI is still in, I mean, it was only a year ago that ChatGPT kind of like came on the scene and really kind of galvanized interest. And so I'd say it's a little bit too early to do it. And we just don't, there's a whole bunch of stuff we don't know. One of the things that I do in the paper is give examples of, this is going to have devastating effects on the industry, and it turned out actually not to be so bad. And so, one of the things that I will also point out is that a lot of the big companies, in fact, like OpenAI, are making deals with copyright owners. There was a deal announced with the Associated Press. I know they're in talks with the New York Times and with a number of other, where you can get an aggregation, right, of stuff, but you can't actually negotiate with everybody, post a picture on the internet. It's just not going to be feasible to do. But voluntary licensing, kind of on a kind of, here's a big cluster of stuff that would be good training data, I think that's actually a positive thing. And so, but again, I'm going to say that just because some of these people are licensing, it doesn't mean that everybody has to license. Leaving a little bit of room for fair use here, I think, is a sensible approach. And I'm glad to hear your father thought this was on the razor edge in the Sony case. And he certainly was extraordinarily influential in, and you've been able to carry that on. So bravo to you, David Nimmer.
There's a wonderful reception outside. Thank you so much. Let's do one more round of applause. You can scan the page, you get your CLE, we will send that to you if you need. And yeah, enjoy the